Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things? Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are.
Hello, lovely people and wonderful family out there. Good afternoon and welcome to another edition of the Community and the Law. It's a Saturday afternoon here in London and in the BW Communications Studios. We are live on BW TV. I'm asking the question, what do I do to have access to my children if my children's mother does not want me to see them? The Community and the Law will be addressing this, and our guest lawyer, Charles Asma, will be on hand to help us with that. And we coming your way courtesy BWF Solicitors, our trusted partners when it comes to the law. The Community and the Law next.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
BWF Solicitors, we want to say thank you very much for your kind sponsorship and everything you do for us. We are here and we're bringing to the community and the law, a law discussion program that focuses on everything immigration, everything legal matters here in the UK and back in Ghana and other jurisdictions. My name is Ureku Frimpong, and I want to say that I'm happy to be hosting you this afternoon. Now, earlier in the week, we had so many things that come our way, and we are going to look at one of the very basic things that BWF Solicitors put out in the community earlier on. And the first of it is to have our nuggets. But before then, we're going to the BWF Solicitors community, and we're going to wish our practice manager, Madam Cynthia Brown, a very warm and happy birthday. She celebrated her birthday earlier in the week. Remember earlier on, we had her win the Employee of the Month, August 2023. So it's a double whammy there for you. Madam Cynthia, thank you very much for all the things you do for everybody, clients and staff alike. And to us, we say, we have found a wonderful mother. Thank you very much. Congratulations. Winning the Employee of the Month earlier on, and also doubling it up to celebrate your birthday. Happy birthday to you. We wish you all the very best. It was a special day earlier in the week, and I know you'll continue to celebrate it for a very long time to come. Happy birthday to you. We love you so much. We had another wonderful news earlier in the week. BWF Solicitors announced that lawyer Charles Asma, who's going to be our resource person this afternoon, had qualified as a solicitor after 3 years of training. We want to wish lawyer Charles the very best and success in his role as a solicitor as he continues to pursue his legal career with BWF Solicitors. Congratulations, Lawyer Charles. Yes, meticulously, you do everything you do, and we so appreciate you, and we're happy to celebrate your success with you. So BWF Solicitors, those of us on BW TV, BW Radio, and BW Communications, we say congratulations. We wish you the very best in your role as a solicitor. People didn't really realize that you were a trainee as you went on. But now that you are fully qualified to practice and, of course, be a solicitor to the Royal Majesty, we say congratulations. Thank you very much for all you do for us. And I know today we're going to have another few of the wealth of knowledge you have as a solicitor. BWF Solicitors is proud of you. Another thing I want to bring to your attention is that if you would want to apply for your skilled worker route visa, health and care worker route visas, and other specialized area visas, you need to write your English language, the IELTS. The B1, B2, you would have to write. But how do you prepare for that? You just can't just get up and say, well, I'm going to write that. You need to have proper preparation. And I'm recommending KT Educational Consult for you. I'm recommending that because they are the experts that help you write your English language. And as the Ghanaian will say, you would pass once, and it's once and for all. So consider registering with KT Educational Consult for your English language. Call them on 075 966 20154, 075 966 20154, or 07512 644 041, 07512 644 041. Prepare with the experts and pass with ease. KT Educational Consult, your preparation for English language test is the right source and the choice for you. Okay, now let's look at what we had as our point of knowledge earlier in the week. The nugget came out Monday before midday. Those of you who were with us on the program last week, when you go to the BWF Solicitors Facebook page, YouTube, and all the other social media platforms, you have the chance to watch what we discussed last week with lawyer Bernard Owusu last week. We talked about surrogacy. Now, to reiterate the knowledge he helped us have, the nugget was put out earlier in the week and defined surrogacy and transfer of parental rights. Now, let's look at that. You have it on your screen. A surrogacy arrangement is when a woman or surrogate carries and delivers a child for another couple or person that is the commissioning parents. Under English law, the commissioning parents will need a transfer of parental responsibility to them from the surrogate mother and her husband if she is married, before the child is recognized as their child, really, through a parental order within 6 months. Now, let me take that again. Under English law, the commissioning parents will need a transfer of parental responsibility to them from the surrogate mother and husband if she's married before the child is recognized as their child through a parental order within 6 months. Voluntary consent from the surrogate mother and the father, if married, must be provided before the courts can grant the order. This one is quoted from Section 30 of the HFEA 1990 and Section 54 of HFEA 2008. A surrogacy's 54 criteria 2020 case, AWHC 1426. The family dispensation, I should say. So these are the things that you need to really take note of. And as I said, if you missed the whole discussion last week, you can go on to the BWF Solicitors Facebook page, BWF Solicitors YouTube page, and all the other social media platforms and watch that again. It was very insightful. But then we have given you a double dose of that, and this is something you can keep and remember what surrogacy arrangement is all about. It's arrangement when a woman who's a surrogate carries and delivers a child for another couple or person that is a commissioning parent or parent. Under English law, the commissioning parents will need a transfer of parental responsibility to them from the surrogate mother and her husband if she's married, before the child is recognized as their child through a parental order that should be granted within 6 months. Voluntary consent from the surrogate mother and the father, if married, must be provided before the courts can grant the order. Very soon, I'll be asking Lawyer Charles Asma, my resource person, after we have congratulated him, to unpick these and also reiterate the knowledge we had earlier last week. But in the meantime, I want to say thank you very much to BWF Solicitors for being there for us all the time. BWF Solicitors, you can find them on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, London N15 4NP. You can call them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening on 0208 493 7340. The number again, 0208 493 7340 or 077 127 61884, 077 127 61884. BWF Solicitors, if it's an application you've made for any of your immigration matters, trust them, they will deal with that for you. If it's an appeal you want to lodge, deal with BWF Solicitors, they will do that. Now, wills and probate, I've been stressing that in the past few weeks. I want to say to you that you don't know what happens behind you when you are gone. Whatever it is, 6 feet, we are all going to go. But when you go, what happens behind you? Make a will, make your statement, let your intentions be clear that when you are gone, this is what is to happen behind me, especially when it comes to the distribution of my estate. So don't die in intestate, write a will. Get to BWF Solicitors, they will do that. There's a special service they deliver, and they give you everything you need to have. So BWF Solicitors, call them again. The numbers are 0208 493 7340 or 077 127 61884. Let's say thank you to them. I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Well, welcome back, and thank you for sticking and staying with us. Another thing I would really want to remind you of is the fees that were introduced earlier in the month by the Home Office. Now, let me go through some of the fees. Now, leave to enter for persons in the UK who are liable to immigration detention is 1,048 and is going to 1,258. Leave to remain is going up from 1,048. Well, I think that remains there. Okay, now certificate of sponsorship, skilled worker tier 2 minister of religion is going up from £199 to £239. Indefinite leave to remain, main applicants and dependents, from 2,404 to 2,885. Naturalization, that is British citizenship. Previously, as we speak now, you are paying 1,250 and it's going to £1,500. Nationality registration as a British citizen for children is rising up from 1,012 to 1,214. So take note of those things. I'll quickly run over. Okay, let's go to the other ones and I'll come back and run over all the others. Visitors visa for less than 6 months is rising from 100 pounds to 115 pounds. Actually, is rising by 15 pounds to 115 pounds. So visitors visa from 100 pounds to 115. Visa visa long up to 2 years from 376 pounds to 400 pounds. Visitors visa long ones for up to 2 years, rising from 376 pounds to 400 pounds. Now, if you're a student and applying for a student visa from outside the UK, yours will rise by 127 pounds to 490. So remember, if you are a student applying for a student visa from outside of the UK, you are going to pay 490 pounds. If you're applying for settlement, the current fee is 1,538 and is rising up to 1,846. 1,536 rising to 1,846. Now, indefinite leave to enter. Indefinite leave to enter for people who are in the army and all that, from 2,404 to 2,885. 2,404 to 2,885. So these are the fees that have been introduced, and I think from October is going to rise up. Let me go over them again. Leave to enter for persons in the UK who are liable to immigration detention is rising from 1,048 to 1,258. Leave to remain from 1,048, staying at the same time, at the same point, 1,048. So, well, I think it goes with the name. Leave to remain remains the same. Well, certificate of sponsorship. Skilled worker route, tier 2, Minister of Religion is going from 199 to 239. Indefinite leave to remain. Main applicants and dependents, you are going to now pay 2,885, rising from 2,404. So for now, you're paying 2,404, and from October, when these new fees kick in, is 2,885. Naturalization. If you want to naturalize as a British citizen, you are actually paying 1,250 at the moment and is rising up to 1,500 pounds. Nationality registration as a British citizen for children is rising from 1,012 to 1,214. 1,012 rising to 1,214. Visas visa for less than 6 months is rising by £15 to £115. Visas visa for less than 6 months is rising by £15 to £115. Visas visa for longer period, more than 6 months up to 2 years, is currently at £376 and is rising up to £400. Is rising up to £400. So take note of that. Student visa from outside of the UK will rise by £127 to £490. Is rising by £127 to £490. Now we have the settlement fee, which is currently at £1,538, rising up to 1,846. Then the indefinite leave to enter for army, people going to the army, you have 2,404 currently, and is rising to 2,885. Now, if you want any further information on these fees, when they are kicking in, how you can go about it, if you can't afford in any way, shape, or form, talk to BWF Solicitors, 214-218 Tottenham High Road. Call them on 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF Solicitors are trusted partners when it comes to the law.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner. Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Well, thank you very much for sticking and staying. And we're still live on BWTV. The program is the community and the law. Nanajimain, thank you for coming on board. Share is your message, and that's the call message there. Congratulations, Professor Asma. Nanajimai says that Gina do say you are there. Margaret Adu Mensa, thank you very much for staying. Tilly Duma, you are on board. Let's see you. And when you come on board and you register yourself or you make your presence felt, let us also see whether you are sharing or not. So tell people to do that. So ask people to come in and join us. We're live on the program, The Community and the Law, and we're coming your way with a very interesting and very nice discussion this afternoon. Lawyer Charles Asma, who we are all congratulating, qualified as a full solicitor earlier in the week. He has trained for 3 continuous years, and we wish him all the best in his endeavors as a solicitor to the UK. Wimpini Adam, good afternoon, BW Solicitors. Yes, good afternoon to you, BW Solicitors. Thank you for your time. Good evening, everyone. Rebecca Moako tells us that. Next, we have Abena Ativo. Abena, how are you? Long time no hear of you. Good evening to you all. I hope you're doing so very well. Regards to everybody in the family. Thank you very much. But remember to share the page for us. Please, what about immigration health surcharge? I think that is also increasing as well. I'll get you the figure and let you know in due course. Kweku, special greetings. Jima Boachi, my brother, how are you? Special greetings to you too. Where are you watching us from today? Let us know. Good afternoon, sirs, and everyone. Sandra Fraser, she's done what she does very best. She's put all the details in the comment section of both Facebook and YouTube. Thank you very much, Sandra. Please share. She continues to admonish us to do that. Joshua Papamwa Kokini Ameya the first. Good evening to you. Good evening to everyone you say. The next one we have is from Ademununkum. Good afternoon, friends and family. Good afternoon to you. My brother, how are you doing? Blessings. Pastor Augustine Abuaje from PAM or PAM Television. Thank you very much. Oh, Pastor, we're live on your TV as well. God bless you. And thank you for that wonderful show you put up the other day. God bless you. We love you to bits. Derek Yamboa, good afternoon, Oriku and Lawyer. Good afternoon, Derek. How are you doing? I hope you're doing so very well and you and the family are so doing very well. Congratulations, my mentor, my advisor, Lawyer Charles Asma. We are proud of you. Yes, definitely. We're so proud of Lawyer Charles Asma. Asante Bernard, thank you for that congratulatory message. And Lawyer Charles is very proud of that. I know he's beaming with smiles, and when he comes on, he will accept all our congratulations and definitely acknowledge that. Then we have Asari Williams. Good afternoon. You're doing a great job. Asari, thank you very much. We do it for the community. We're so blessed that you are also there on the other side watching with us. The next one we have, I think we're done. So, once again, before I bring in Lawyer Charles, I am going to ask you to consider doing one thing for me. Have you written your will? Do you know where to go when you can have access to that service? If you don't, I'm asking you to go to BWF Solicitors, 214-2218, Tottenham High Road, 7 Sisters, North London, and they will help you do that. And if you're writing your English language, remember to do that with KT Educational Consult, and they will help you succeed the first time. So now listen to this message for the wills and probate, and then I won't waste any more time. Lawyer Charles Asma, I have kept you in suspense. I've kept him in suspense, and I'll bring him on. I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome back, and thank you very much. We are now, as I said, I'm not going to keep you in suspense anymore. I am going to introduce my resource person. Lawyer Charles Asma is a fully qualified solicitor after 3 years of training. Now, I think when he comes on, I'll ask him to explain, because if I do, I will be taking the wind out of his sail. Now, when you finish with your school work, classroom work, you'd have to have some training, practice for at least 3 years before the law fraternity will accept you into their midst as a fully fledged member, and they will start calling you my learned friend. Lawyer Charles Asma, congratulations. We wish you the very best, but we can't let you go and say, well, he's qualified, so he's not going to teach us anymore. He is going to lead us in our discussion this afternoon. Let's bring on our friend, our brother, and the celebrant of that success, Lawyer Charles Asma. Congratulations.
Thank you, brother.
Well, I I know that when you have the such a feat, and with you being your humble self, I hope I'm not going to kind of overwhelm you. But let me gladly and with all excitement put it this way, in quote, embarrass you. Congratulations, well done.
Thank you. Pleasure.
You deserve it.
Glory to God.
How does it feel?
It feels fulfilling. It feels opportunity to take up bigger and better challenge. It feels that you have what it takes to be a blessing and to make other people smile and feel fulfilled and empowered as well. And therefore, I say that everything else is now starting. Everything else to the effect that you now can do more than you have already done to empower the community, to make positive contribution, and to let your presence felt within the community in terms of support and advice, encouragement.
You have been doing that already. There was one comment there from um, one of your mentees, Santi Bernard. He says, "Congratulations, my mentor, my advisor, lawyer Charles Asma. We are proud of you." So you have affected the community already.
We thank God that sometimes you do what you have to do, and if you do it with the best of will and intention, indirectly people would then benefit. So it's I would say that you don't do it deliberately to help anybody, but you do it as a free will and as something that you need to do, and eventually somebody will learn from you, somebody will pick A or B from you. Yes, we've been doing what we've been doing, but we thank God that for now we have the license to practice fully to the effect that your name is recognized by the Law Society and also the Solstice Regulatory Authority, so that when you speak, you are speaking the voice of the authority and also the society, so to speak. And therefore, yes, it's a pleasure to get to the point where you now know that, yes, you are not just affecting the community, but you are affecting the community positively and even more.
Well, if you have had the benefit of dealing with this very humble yet knowledgeable man, I won't call him a young man, but well, he's young in the fraternity. So join me, all of you, with the BWF Solicitors family. And I was saying that if you had a chance to meet him, you have had an encounter with him, you will feel his humility, his the tenacity to get you to feel that you've gone to somebody who is going to handle your case for you. And the confidence with which you will leave his presence tells you that, hey, my case is going to succeed. He's done it. And even now that he's going to be recognized fully in the Law Society, recognized fully by his peers, they're going to rub shoulders with him. He's going to give us a lot more. So, on behalf of our viewers, on behalf of all clients, and on behalf of the BWF Solicitors family, and on the behalf of Lawyer Bernard Owusu, I want to say congratulations to Lawyer Charles Asma. Now I can confidently say, my learned friend.
Pleasure to be a learned friend. And let me also take the opportunity to say thank you to the unseen mentees and unseen mentors. So we look up to people, we get advanced. Sometimes what we read on the comment role in terms of what we are doing inspires and spurs us on to do more. And I want to take the opportunity to thank Uncle Ben and BWF Solstice firm for the opportunity, because many of my colleagues have completed law school, have completed even their LPC, yet what it takes to be able to get to the next level is the training contract. And if you don't get a training contract, the academic work does not really go far. And therefore, to get a firm and somebody like Uncle Ben to give you open arms and to help you to achieve the dream, it's refreshing. And therefore, I want to say thank you, and I want to say that God bless you for what you are doing for the community. And yes, you were asking how long. It's taking a while. Some of us decided to go through from the beginning. So you go to law school, you do a degree, you go to the next level of law studies. We call it a legal practice course. Now it's called SQE. And you move on to do training contract. The standard is 2 years, and sometimes you can even do more depending on how you start your training. And therefore, once you finish, and if the SRA is satisfied that you've ticked all the boxes, and not just the boxes, but also making sure that you have been screened for credibility, for integrity, and your record is intact to the point that the community, the public will have the trust and confidence in you. And I want to say thank you to God. I want to say thank you to my family and friends. I want to say thank you to Uncle Ben again, all the people who have in one way or the other supported me in this journey. And I also want to dedicate this to the memory of the late Patrick Asma, my father, who left in 2017 when I had already started the journey. He's not physically around to see the end of it, but he's in heaven, and I know he's seeing the accomplishment. So to his memory.
Well, that's a very touching something there. I know how it feels. And congratulations to you. There's one very special message from Sandra Fraser on the platform. It says, congratulations, Gang Lawyer Charles. Indeed, you are one of the best lawyers I know. Yeah, it's an understatement. He is real good at what he does. And once again, congratulations to him. But well, let's draw on his knowledge. I was talking about the surrogacy thing earlier on, and it's an arrangement when a woman carries and delivers a child for another couple or persons. That is a commissioning law. Lawyer Osman, fresh from the oven. Can you help us unpick this one?
All right, so we'll leave it on the screen so that people can follow us in terms of the learning journey within the NAGET process. So we are talking about somebody who is giving birth for another person, not to another, but for another. So when somebody is giving birth for another, we call that surrogacy arrangement. And people, through biological processes, may require that arrangement to be in place so that they can have children of their own. Now, once the arrangement is in place, that person, the surrogate mother will carry the baby for the person who commissioned the surrogate mother. So let's call the surrogate mother the support mother.
Okay.
And let's call the commissioning mother the needing mother.
Okay.
So the needing mother needs a baby, and the support mother is the one helping the needing mother to have the baby. What it means legally is that the person who is carrying the baby biologically has given birth to that baby. But because it's an arrangement between A and B, they have to ensure that that arrangement is effected in law. And therefore, under English law, within 6 months, you have to ensure that there has been a transfer of that ownership in terms of the birth to the one who needed and commissioned you to do that. And if you go further, it says that there is a voluntary consent from the surrogate mother and the father. So if they are married, then of course the couple. If not married, there will only be the mother. And that consent must be provided before the court can grant an order What is the order? The order we need parental responsibility for that child. So you have to become the mother or the parent of that child. And once that transfer is made or done, you have taken ownership. And the surrogate mother is no longer the owner of the baby or the mother of that baby, so to speak. And if that arrangement if that process is not completed, then the surrogate mother can still say that I am the mother. And indeed, that person is the mother biologically. So there's a case law to that effect, and there's also statute to that effect. And therefore, you can see that it is possible for anybody who may not naturally be able to give birth to have a child of their own by going through the surrogacy arrangement. And each country has its own surrogacy laws. So we have surrogacy law, every country, depending on the country, whereby in the UK, the laws are quite clear that once the arrangement is in place and the process ends by the time of birth or the time of birth, you have to make sure that within 6 months, the transfer process has been effected, and you can agree by consent, and the court will endorse it.
Well, with that, we are moving straight into our discussion. So remember, surrogacy arrangement is what Lawyer Charles Asma has explained to us, is giving us the scenarios and what needs to be done. And somebody would say the common sense behind it, because if somebody's done that for you and you don't legalize it, let me put it that way, go to court, get the consent, and make sure that there are no disputes around it. The person can come back later on and say, well, I verbally gave you the consent, but I'm not going to have that again, so I'm taking my baby back, and that will be a problem. So within 6 months after the baby is born, please make sure that the parental order is granted and you would have your legal status as the parent. Well, with that, we're going to go into our discussion. My children's mother does not want me to see them. Do you relate to that? What do you do to have access to your children? Have you thought of that? Have you found yourself in a situation like that? I am going to help you unravel that, because Lawyer Charles Asma and as BWF solicitors, they do all the time. They have the strategies, they have the wherewithal and the knowledge to help us do that right after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, now we're welcome back. Let's get to discuss the topic that I raised earlier on. My children's mother says that I won't let you see your children. What did you do? What's your crime? How do you take care of that situation so you can have access to your children? Lawyer Charles Asma, this is when somebody saw the advertisement go out earlier, and the person was like, I can't share this because I know people who are at either side of the whole equation. One, a friend says, I won't let my or won't let the husband see the children. I have a husband or somebody, a husband or a father, whose children's mother says no. So the person is caught in between and say, no, I can't get people to know that. But we need to have that knowledge. What happens that a woman who has had, or a mother, let me put it that way, that's a more correct term. A mother would say to the father of her children, I won't let you see them.
Right. So, I mean, when love wins, there tend to be acrimony. Because the love that brought the two together resulted in the childbirth, potentially. And if that is no longer there, then the understanding that we have to be together in the interest of the children may be shaky. There are so many reasons why the parent may not continue to be together, and therefore it might be the case that the children live with one parent. So if the two are married and there is divorce, it's a case of the children usually living with the mother.
Okay.
If the mother, for example, has passed on, it's a case of the mother's family saying that we are taking care of the children.
Okay.
To the detriment maybe of the father.
Okay.
There could be so many reasons. Today, even though the topic looks at the father being able to have access, we are also looking at the mother potentially also having access.
Okay.
So father here represents both parents, but it's always the case that the children will be already living with the mother or the mother's relative or the mother's friend, and therefore the father will be seeking to have access to the mother.
Okay.
Or the mother will say, you know what, I don't want you to see the children for whatever reason. The reason could be that the man's behavior. The reason could be that the lady says that, you know what, I don't even see you as the father of the children. It could be any other, but these are some of the reasons. And therefore, when it gets to that point, with the father or the mother, in this case, the topic looks at the father wanting to have access.
That's okay.
The father, legally, if can prove that he is the father of the children, then can have access. But that access could be formal or informal. If informal fails, then you go through the formal. The question asks, what if the informal has failed? Because if the mother is not willing to let me, then what do I do?
I'm looking at a situation where the acrimony is there. The interest of the children is paramount. But one parent insists that I won't let you do this. It often brings sometimes violent exchanges between them, very bitter exchanges between them and the rest of it. In this situation, do the children have a say?
So, there are instances where we will look at what the children also want. Whether they want the requesting parent to be part of their lives. And normally the child should be of age to be able to reason to decide that yes or no. And we say that when a child is about 13 years, thereabout, the child is able to reason and to make informed decision. Before or below that, we only assume that somebody will have to make that decision for the child. So when a child is up to that age, we say the child is legally competent. So there's case law to support the fact that if a child is up to that age of 13, then they are able to reason and be part of the decision making that concerns them. So in that case, yes, the children will have a say.
Let's look at some of the basic things in this scenario. Would it just necessarily be bitter relations between the two of them, a breakdown in the relationship, or it could be one of the parents exhibiting a behavior that is not conducive to the development of the children, that one would say, nah, with this your attitude, with this your behavior, I'm not allowing you to come in and see the children. Does it happen like that?
Yes, that's a plausible reason. So as I said, the reasons are non-exhaustive. So that anything that may make the woman decide that I don't want you to see the children will trigger that point. There are instances where the woman, for example, may be unwell, and the woman may have given the children or the child to somebody else that the woman maybe sees as mother or aunt. They may not necessarily be biological, or they not be family members, but somebody they look up to. And if that person they look up to now takes over the care of the children, because the mother cannot, then invariably to a point that person sees themselves as being the one with guardianship right to the children. And therefore, if the father even wants access, they may even decide, well, we didn't get the children from you. So if you want permission to see your children, you have to speak to the children's mother. If the children's mother is not able to give that consent due to illness, then what do? So the person can give you that permission, and the B, who is also taking care of the children, saying that go to A. So when you are left in that limbo, you can only take the formal process.
Right. We'll be coming to the informal bit and the formal bit, where we're finding solutions to that. But what gives one of the parents that, for lack of a better expression, to the lay person, the audacity to say that I want to let you see the children? What power does any one of them have to do that?
So, as you earlier said, if the other parent feels that the father's behavior is not conducive to the well-being and interest of the children, she can say, no, I don't want you to see the children. It might also be the case that the father has relinquished his responsibility as a father for a long time and now wants to come back. And if the mother is not satisfied, she can say, you know what, no, you've been away for the donkey years and you want to come back. No, let me think about it. All these things can be the reasons.
Okay. So let's look at the informal way of resolving this matter. If you make the effort to go see the parent that is not allowing you to see the children, how do you approach it?
So first off, we have to understand that when it comes to children, the law that regulates these processes is the Children Act 1989. So we have different sections. We are not going to go through the law, but we are going to make reference to what the law requires A or B to do.
Okay.
And whether you have the right within the law to do what you want to do. So the law expects you to be a parent.
Okay.
And therefore, you should have that parental responsibility.
Okay.
The law says that the mother of the child has utmost parental responsibility.
Okay.
Father of the child could be anybody and could be nobody. And therefore, if the mother says that my child has no father, the law allows that to pass. That's why there are instances where when the children are being registered, they will ask, where is the father? If the mother says there's no father, there will be no father on the child's birth certificate.
Oh.
It's possible, and it is sometimes the case. So, if the mother says that my child doesn't have a father, Somebody may ask, how can you have a child without a father? But we say that only the mother knows the father,
of the child.
the child. And therefore, if the one who knows the father says there's no father, why question? So she would then say that this is the father's name will go on the birth certificate. So if your name is on the birth certificate, then you are a father, named father. And therefore, the law recognizes you as a parent and you will have parental responsibility.
Okay.
So we have the mother, we have the father, the biological father. It's also the case that the mother might have married another man and the child becomes the stepchild of this husband.
Okay.
Therefore, the law sees this stepfather as somebody with also parental responsibility for the child. So we have the biological mother, the biological father. Okay, so let's put even biological father aside and call it the named father, the documented father. So the named father, documented father, per the birth certificate. We also have the stepfather. We also have somebody who has permission within the law to provide guardianship to the child, what we call the guardian. So if there is guardianship order in place for somebody else, a third party, then that person will also be a parent and will have parental responsibility. Parental responsibility simply means that the responsibility the adult has to play the parent role in the life of the child. Okay. So all these people we have mentioned have that position.
So in that case, if you the neglecting parent, I just don't want to limit the father or mother, but the neglecting parent, if you would want to have access and you want to go the informal way, all these stakeholders will have to be consulted and they will have to give consent before you would have access to the children.
Right. So we know so informal way simply means that we want to do it without going to court. Okay. Because it's very expensive to litigate and it's time consuming. It's also emotionally draining and it's also inimical to the welfare of the children. So we don't want to go through that process because this process can take 2 years, 3 years, some can take 4 or 5 years. So you don't want that because it will affect the child as well. So the first thing the law requires you to do is to find what we call alternative way to resolve the misunderstanding and to agree how the arrangement will be so that we are both able to support the care and support of the child. What it means is that you speak to the mother. The mother may agree, okay, that's fine. I'm going to allow you to see the children once a week.
Okay.
That is something. And I'm going to allow you to see them morning, afternoon, or evening, depending on what the agreement turns out to be. Okay. So if you agree on that basis, that is your agreement, and you can effect that. You don't have to go to court. That's one point.
That's okay.
If that doesn't work, then you have to bring in the church, elders within the community, the family in to help you resolve your misunderstanding in the interest of the children. So we call that mediation process. It's an alternative dispute resolution arrangement. So even before you take the formal approach, the court will ask you whether you have resolved through the informal way. If you haven't done that, the court will ask you to go back and seek to resolve it informally. So there's always a requirement for mediation. There's a requirement for informal arrangement to resolve the matter. If that doesn't still work, then of course you go to court to give you permission or order to be part of taking care of that child. And the arrangement that you could not agree, the court would then put it together for both of you so that you both have equal share or fair share of helping or being part of the child's development.
Let's look at the other side of the coin where you have exhausted the informal method of doing that. It hasn't worked. Or can I just, from the get-go, go to court and say that I don't want any situation where one will give me a verbal agreement, then later on renege on that and say that I'm not giving it to you anymore. So first off, I go to court and ask that this permission is granted me. Do I have to do it that way? Or I will have to exhaust the informal bit before I go to court?
So the courts are not there to serve as first gateway to resolving problems.
Okay.
They are more or less last resort.
Okay.
So when you have exhausted your options, then you go to court because it's very expensive. And the court actually encourage us to go through the informal process. So if you go to court without first resolving it informally, the court will ask you to go back and find a way to resolve it.
Okay.
So the court will ask you, have you attempted to resolve it informally? If your answer is no, the court will ask you to do that first. If your answer is yes, they will ask you to prove it. When, how, and what was the outcome.
Okay. So can I ask that whatever informal arrangement I have with whoever is preventing me from seeing the children, that we have agreed on that, then I'll take to court for ratification?
So that is the second option. So the second option will be that we know that even what we've agreed, we cannot effect it to the end. Then you can go to court and tell the court that we have agreed, but we want to formalize the agreement. So you put together a consent order. The court will stamp it, and that becomes binding on both of you, so that none of you can go behind and say, oh, I'm not going to do that. Once the court approves it, you have to. What the advantage is that you don't go through the court process for the judge to say, this is what I want you to do. You both have agreed, and the court has approved or sealed it, and that becomes the order for you, consent order. But let me say here that in terms of that process, what is it that the parents actually need to do for the children, or what the other parent may need? So the agreement or the arrangement may be that, you know what, we want to know where the children will live.
Okay.
So the live with arrangement. Or and. So it could be all, or could be all and. So you can have a bit of this
And a bit of that.
So if it's a case of where the children will live and where the children will spend time, then we can agree that, you know what, they're going to live with you, but they will spend time with me. Or all I want is that the children spend time with me every weekend, because I'm even busy during the week. Then the mother can say, okay, that's fine. Weekend, they come and spend some time. What it means is that they will not be sleeping there. They will spend time, then they go back. So all these arrangements can be in place. What it is that you must show that you have parental responsibility.
Okay.
If the parental responsibility is not there, or you are not recognized as a parent, then as part of the formal process, the court can give you parental responsibility before they grant you the permission to do that. So within the law, there are certain things that parents do for the children. We living with our children and taking care of them. We preventing certain things from happening to the children, what we call prohibited steps order. And we making certain decisions for our children, what we call specific issue or issues. So if it's a case that we cannot agree on the decisions, the court can come in to help us to resolve that, what we call specific issue order. And what's the specific issue? For example, which country should the children live in?
Okay.
What name do we give to the children? Should we change the name or keep the name? What school should the children go to? What religious faith should the children adopt, build, and pursue. Because they are children, parents have to make those
decisions. Yeah.
And therefore, when it becomes contentious between both parents or those people who have parental responsibility, then we go to court for the court to resolve that issue for us. Or prohibited steps. One wants to do a particular thing, and the other feels that that is not in the interest of the child. Then the other will go to court to say that I want the court to prohibit or prevent this person, this parent, from doing this. What could that be? The child was born in England, brought up in England, and all of a sudden one parent says that I'm moving the child away because it's better elsewhere than here, without the other parent's consent. Then the other parent can go to court to prohibit that person, the other parent, from pursuing that. As for the children, they follow whatever we tell the child. If the child is 13 or above, the child can say no, because they are legally competent.
All right. And if you just joined us, we're live on BWTV, and Lawyer Charles Asma, resource person, is taking us through what to do to have access to your children if the child's mother or one of the parents is preventing you from seeing or having access to your children. I know you have questions, you have concerns, you have issues you want to bring up. The text number for what you can send us is 0739920848. You can call that number as well. If you have a WhatsApp message or WhatsApp audio note, you can send that to our WhatsApp number 07950422780. 07950422780. Yes, follow the discussion, follow with us, leave your comments in the section below. And I know so many people out there. Share, so we have so many people also having access to this whole thing. Now, the question is, what do I do to have access to my children? We've looked at the informal bit, we looked at the formal bit, but we're going to go into some further details as to what practical steps we take to get that consent from court, and what the laws really talk about, and how our dear lawyers can help us go through those things as well. And as I mentioned earlier on, Lawyer Charles Asma is our resource person, and we're doing this courtesy of BWF Solicitors. We'll be right back.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208-493-7340 or 077-127-61884. BWF Solicitors, your trusted legal partner.
Welcome back, and thank you. Here's the numbers on the screen: 073-99-208-468. WhatsApp 07950-422-780. 07950-422-780. Or leave it in the comment section below. We'll pick that one up. Lawyer Charles Asma is here. We're doing this courtesy BWF Solicitors. We're going to look at the practical steps to take when it is that you are applying for such an order or making sure that the law backs you when you have the need to ask for such a thing to be done for you. Now, let's see how we can do this. What are the steps? How do we go through this whole legal process?
Thank you very much. So, if the matter has, depending on whatever has happened, been involved, or the state has gotten involved, and the state here we are looking at the social service. If the social service is involved, then we are looking at different parties to this. And that is why it's always important that the two of you can resolve it before it even goes to the state. So, if the two of you are not able to resolve it and the state is involved, we are looking at the state interest towards the child. We're also looking at your interest as one parent and the other parent's interest, and anybody else who has parental responsibility, their specific interest. So it becomes a tripartite, or it can even be a multi-party sort of interest to be resolved. So we have different groups. One group that often comes into this is CAFCAS. Once it involves the council, CAFCAS will come in. And we have the court-owned process or system that CAFCAS will help to support in terms of the assessment of the need of the, or needs of the child. CAFCAS simply means Children and Family Court and Advisory and Support Service. So within the Children and Family Court, there is Advisory and Support Center or service. So the moment the matter goes to court and it involves children, automatically CAFCAS will have to intervene or get involved.
Okay.
Then if it's a case where council is also involved, we'll have the social service as well. So all these parties will have to bring their assessment as the process goes or progresses. So if you are, let's say, parent A, seeking an arrangement or child arrangement or prohibited step order or specific issue order or consent order, because today we are talking about how to have access to the children, we are looking at child arrangement order. If you want the child arrangement order to be given to you through the court process, you have to complete a form and send the form to court. So you, the one making the application, you complete a form called Form C100. Once you complete the form, it's a family law form, you have to make sure that you have gone through each step or each session. We are not going to look at how this is done to the point that everybody will then say that, all right, then I can just do my own child arrangement order application to court. We are showing you what the process entails. Okay. You are empowered to do so if you want to. If you need a lawyer, of course, the lawyers are there. We are there to assist. But suffice to say that this is the form that you need. You have to go through the steps to fill the form. So you can see that it says application under Section 8. So Section 8 of the Children Act 1989 tells you the various orders that you can seek from the court as far as the children's welfare and interest is concerned. So this form can be used to seek an order for the child arrangement or for the specific issue or the prohibited step or consent. So you start with the first part, the person making the application. Okay. Somebody will ask, what about the bit about the court and the this and the that? That is for the court to complete and give you the claim or the application number. Your name as the applicant, if you are the father seeking order from the court to have access to your children, you complete that form. If you are the mother seeking order from the court, you do. Or if you are any other person with parental responsibility, the same form. Once you finish, you move on to the next session, covering the children. The name or names of the children, age, date of birth, and so on and so forth. You move on to the next step. It will ask you to provide information about the order you are seeking. You have to specify what you want the court to give you or to grant you. You also have to specify if there are safeguarding concerns or issues. So if I, the applicant, consider that there are safeguarding concerns that requires me to have access to my children, or I want to be part of the children's care, you have to specify. And you have to make sure that you have evidence to support that. So it's not enough to say that, yes, there has been safeguarding concerns, this person has done that to the child, and therefore I want to get involved and all that. So you go through all this up to the end, and there are different courts or family court. So if you live, wherever you live, you identify the particular family court and you make the application to the court. You also have to pay the court fee of about £232. Then you file to the court. Do you need a lawyer to represent you? As I said, this can be a very lengthy process, and therefore from the outset you can do this through the lawyer. If you are doing this through the lawyer as part of the informal process, the lawyer can even write to the other parent to seek to help you to have the arrangement between yourselves. Then you only seek the consent order so that it quickens or shortens the process. But if not, then you can see that the form alone is enough to put you off if you are really not determined. And therefore you need a lawyer to assist you. We are not saying that you can't do it, but you have to get it right, because you are making an application to court. If the application is invalid, then the court will not entertain invalid application. So once the application is
Okay, Lawyer Charles Asma was taking us through the form, but he mentioned that you do not necessarily need a lawyer, but I would advise that that form in itself is about 33 pages, and to get anybody sitting down doing that, I think I would advise that you speak to a professional. But Lawyer Charles Asma, when the two parties have spoken probably to a lawyer, we've gone through the details, what the expectation of either side is, and they have done that. Is it a lengthy process, and when the order is granted, can one of the parties go to court and seek for a variation of the order in any way, shape, or form?
So the court will not just grant the order, it goes through the process. And it is the order you are seeking. So what then happens is that once you make the order, you have to make the application to court, specify exactly what you want, you pay the fees, the court will write to the other party, informing them of this application. The other party will be given the acknowledgement form or the response form to complete. And if they also have something to say, they have to make their counter. It's not a counter application. Let me just say that whatever they also want to add. So on the response form and the other form, they give them, they have the right, or they have the opportunity to also state their point, but the response form will help you to agree or disagree what the application content suggests. So if the person has suggested that on the application form that there has been safeguarding concerns or abuse of a sort of the children, you have to be able to respond. Because if you don't respond to rebut or to disagree, then in principle you've admitted. And if there is safeguarding concerns on your part, making the other parent unable or unwilling to allow you to see the children, then the court may agree with the other parent.
Right.
So there will be safeguarding point to address. Or if the form does not make any safeguarding point, then you don't really have to address that. But if there is, you have to address by agreeing or disagreeing. And if you disagree, you've got to explain. So there will be opportunity. The form will tell you when to respond by.
Okay.
So it's not a case of here, how long should I respond once I receive the response form? The form will tell you, respond by this. So you have to make sure that once you receive the form, you check when you have to respond. Then you respond by that. If you don't respond, then the other party can go to court to request the court to continue or to grant the order, because the other party did not respond.
Okay.
Now, you are asking whether there could be counter or there could be variation. It depends on the response the other party is providing.
That's right, yeah.
So if the other party provides this, and that response, then that will go through, there will be opportunity for the court to narrow the issues. So there will be issue narrowing hearing, what we call the first hearing. So the first hearing is issue hearing. The court will call both parties to meet, hear the issues. There is the issue about who looks after the children, who sees the child or children. Is the issue about specific name or anything like that, or what is the issue about? Today we are talking about access to your children. So it's about arrangement of the care of the children. So if that is the issue, what are we looking at? Are we looking at number of days or the hours in terms of the arrangement? Then, and or even where the children can be allowed to go. So if that is the point, the court will address that by narrowing the issue. Once the issue is narrowed, we move on to the next stage. There will be opportunity for assessment. The assessment, as we earlier mentioned, comes from CAFCAS. So the court's department for advice and support will come in to look at how to support the children through the process, and also how to support the family through the process. It can be very emotional draining. So CAFCAS will come in. CAFCAS will have to do an assessment and provide a report.
Okay.
What is happening? Is this order being sought necessary or in the interest of the children? So CAFCAS will put its report together. If the case, or if the state also has interest in terms of the council or the social service, they will also say that no, we don't want the children to live with this particular parent, especially where there are safeguarding concerns. So they will also bring their points. So it becomes a multi-party sort of litigation. And it is up to the court to resolve. And because it's going to require assessment, issue identification, issue narrowing, and so on and so forth, it's not going to be a day or two or a month. It has to go through processes.
Okay. So when there's an agreement and the judge is going to grant the order, is there a time limit? Say I'm granting this order and these arrangements are to be put in place for, say, 6 months, 1 year, 2 years, and it has to be reviewed. Is that normally the case?
Potentially. So where there has been assessment and the court concludes or determines that the assessment does not pose or suggest that there's no danger to the child living with the other party seeking to have access, then there could be interim arrangement just to test or trial the person who is seeking the order. So if you are the father seeking the order, as the topic suggests, they can give you trial period. If you passed your trial, then the court can say that everything is fine, and therefore they don't see why they cannot grant you the order.
Okay.
But if things are not fine, or you haven't not lived up to your parental responsibility during the trial period, then it is likely that the court may not grant you the order you are seeking fully or even in part.
Okay. Now, this order, can it come as a consequence of one parent seeking restricting order? For instance, one parent is abusing the other parent or abusing the child emotionally, physically, and the rest of it. And one parent, one of the parties goes to court and say, "I want to restrict this person from coming closer to us." Then that is granted. The parent that is restricted, can he or she go to court and say, "Okay, fine, you restricted me, but I want to have access to my children and have contact with them. Can I, as a result of that initial restriction, ask that we have this consent agreement?"
So if there is domestic violence, what it means is that the father, mother, child live together. And the behavior of one is such that it puts the other in danger. So we'll ask for non-molestation order from court. So that's called non-molestation order. That is different from the 4 orders that we have specified here. So child arrangement order, specific issue order, prohibited steps order, or consent order will go through this form that we have specified. But if it's about molestation happening to one by the other, then the person who is the victim or the one being abused will seek a non-molestation order from court to prevent or restrict the other person from continuing to molest them. What it means is that once the order is granted, they will also have opportunity to add what we call occupation order. So occupation order means that you cannot go near them so that you can have access to them. So non-molestation means you cannot harm them or molest them. Occupation means you can't get close or closer to them. And that is where they can tell you that if this person lives in this vicinity, you can't get closer within 5-mile radius or 3-mile radius. So the restriction within a certain perimeter. So that is a separate application. But that is only where there is abuse.
Okay.
There might not necessarily be abuse when it comes to child arrangement, but just that the other party is preventing the other. It might be that the mother said that you are not the father. The father took steps to go through DNA process and now proves that I am the father of the child. What then happens is, now that I am the father, can I have access? And the other one may say no. Then this one will take steps to go to court to get an order if they cannot agree by consent. It might also be the case that, as I said, the mother is not well. There are instances where mothers give birth and they go through postnatal trauma, and such postnatal trauma may put them in a position that will not be appropriate for them to be a responsible mother to their children, because the father is not in the scene. So if there's somebody who has been there for them and the person is allowed, be it a family member or church member or church ministers of religion, whoever is responsible is taking care of the children, and the person has assumed that parental responsibility or the guardian of that child, what it means is that even though the mother is not there, they are taking care of the child, and you need them to transfer it to you. So you still have to go to court. So there are instances where once the matter goes to court and the court agrees, first they will take the parental responsibility away from the one who, the third party who has assumed responsibility. And if the mother can be tried to see whether they can be part of taking care of the children in terms of, depending on their health situation, the mother will be given opportunity in that respect. But the father who is seeking the opportunity to have access to the children will be granted parental responsibility and also access. The access could be that live with the child, or the access could be that start by having contact, what we call a contact order. So the contact arrangement may be that you see them in the afternoon, go to school and pick them, take them to where they live and go back, and so on and so forth. And if you're able to prove that you are credible and able to, the court will trust you with more responsibility.
Well, the whole issue, it's about the court granting it and doing it in the interest of the children. Your text messages are welcome, 07399208468 or WhatsApp 0795042270. Kenneth Ofori Kofi Aboateng Antobam, you are watching and listening to us from South Wales. Thank you very much. Greetings from Wolverhampton. Keep up the good work. Effie Bafo, that is yours. Nana Ekuyabreye Ajimai, thank you for being on. Dr. Sadom, we have had you on there. Thank you very much. Tilly Juma, thank you. Dr. Sadom says, good evening, Lawyer Charles and Bra Kweku. Nana points there. Tilly Juma is asking us to share, and share. Now, there's one question here, not necessarily about what we are discussing, but I will pick that one up. It says, I have been granted 30 months, 2.5 years leave to remain status on the 10-year partner route under paragraph DLTRP 1.2 of Appendix FM since 2020. The permit expires in December 2023 and is due for renewal. My partner and my twin kids recently attained indefinite leave to remain status. I'd appreciate if you could kindly advise on the following. 1. Which route can I switch to based on the above circumstances to shorten the 10-year route? What are the requirements? Which application form do I use? Laura?
Okay, so what the children or the mother has nothing to do with you. So first off, this person has been granted the initial 2.5. Other, and I think it's as a parent. Was it parent? Granted as a parent?
Under paragraph
Partner.
D.
Okay, so as a partner. So based on the partner, you've been granted 2.5. Discretionary. What it means that he didn't meet some of the requirements, so he was put on the 10-year route. Now, once that has expired, you have to renew.
Okay.
If you don't want to renew, you have to switch. But here is the catch. When you are living with the partner and the child, and you switch, instances are you are put back on the same thing. Because I don't know why the Home Office does that, but that's what they do. The experience is that even if you are switching within the family, they will put you back into the family, literally. So what can I do? Unless you're able to prove that this time you don't live with them.
Okay.
For whatever reason, you are living apart. The child is living with the mother. You are living somewhere. You have direct access to your child. Then the law allows you to rather switch. I don't know why. However, if you are this time going to make FLR marriage, let's say my wife, then in this case, you are going to make an application based on your wife. And you have to show the marriage, you have to show the income, you have to show all that. In this case, it's not based on the child. It's based purely on your marriage to your spouse or your partner. So it depends on the context, and we have to explore. There are instances where you switch and you are put back. Meanwhile, you have done the English language test, you have shown the money and everything, but you are put back. And they will tell you that you are still dependent on your children, but you are with your wife. Yes, fine. that you are depending on the children. So you are put back on the 10-year route. Next one. The next question was what form? And so
Yeah,
on and
what
so
form
forth.
should the person use?
Yeah, so the forms, if you are switching and you qualify to switch, you go still under FLRFP, but there's 5 year, there's 10. It's not the form that tells you this is 5 or 10. It's the requirement that you meet. So if you don't meet the requirement, you'll be put under. So you then do your assessment will be based on Gen 3.2, which is the family unit arrangement, or EX1, direct access, where you have exceptional circumstances, but you have direct access to your children because you have parental order from court to be able to see your children. You don't live with the mother of the children, and you don't live with the children, but you have contact with the children. And so you play active role in the life of the children. In this case, you have direct access. It is switchable. If you have married the woman this time, gone through the process, got your marriage certificate, and you are dependent on your wife to make the application, switchable. So the form depends on what specifically you want. If it is your wife, then you use the form FLRM, not FLRFP.
Okay. Well, you can send in your quick question, but very soon we will be going over to our quiz, and that will also be dependent on the nugget we brought you earlier on, talking about the surrogacy situation. Nana Hima says, congratulations, lawyer Charles Asma. Naima, yes, we so celebrating with our brother. He's done so very well. You see how bright he's looking today. It tells you that victory has come. And, we need to have a party. Definitely, he would throw a party and we'll attend. And to you, my godson, Gerald Ureku Kwamina, thank you very much. You just sent me a text message. That's so very encouraging of you. You're watching us on TV. God bless you and all the other brothers that you have. And to your mom, Yvonne, thank you very much. Well, folks, I think I will quickly look at our nugget again, take a quick break, and I pose my question. And the question I'm going to pose is about the nugget I gave you. So let's look at that again. A surrogacy arrangement is when a woman, a surrogate, carries and delivers a child for another couple or person that is a commissioning parent. Under English law, the commissioning parents will need a transfer of parental responsibility to them from the surrogate mother and husband if she is married before the child is recognized as their child through a parental order, and that's within 6 months. Voluntary consent from the surrogate mother and the father, if married, must be provided before the courts can grant the order. Now, I'm going to pose the question. Then I'll take a break, and when we come back, I'll ask you to give me the answers. So let's see what the question says. Annabelle Grant, a British citizen and single mother, commissions a surrogate arrangement in Ghana through XYZ Hospital. In January 2023, child X was born to the surrogate mother, Beatrice, using a fertilized egg from Annabelle Grant and donor sperm. Beatrice was unmarried at the time. I go over the scenario again. Annabelle Grant, a British citizen and single mother, commissions a surrogate arrangement in Ghana through XYZ Hospital. In January 2023, the child was born to the surrogate mother Beatrice using a fertilized egg from Annabelle Grant and a donor sperm. Beatrice was unmarried at the time. Now, 3 scenarios. What does the English law require before Annabelle Grant is recognized as the mother of child X? Let's unpick it very well before I go on a break. Annabelle Grant is a British citizen and a single mother. She commissions a surrogate arrangement in Ghana through a named hospital XYZ. In January 2023, the child was born, child X, was born to the surrogate mother, who was not named here, okay? Okay, now the name comes, Beatrice. And they use a fertilized egg from Annabelle Grant, which is the commissioning mother, and a donor sperm. Beatrice, the surrogate mother, was unmarried at the time. What does the English law require before Annabelle Grant is recognized as the mother of the child X? 1. Child X must live with Annabelle for 6 months. 2. Annabelle must apply for a British passport for her child. And 3, Annabelle must apply for a parental order within 6 months of child X's birth. 1, the child must live with Annabelle for 6 months. Annabelle must apply for a British passport for her child. And Annabelle must apply for a parental order within 6 months. Think about it. I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Okay, we're back. Annabelle Grant, British citizen, single mother. We have this scenario here on our hands. So let me see what answers you have. Is it 1, the child X must live with Annabelle for 6 months? Is it 2, Annabelle must apply for a British passport for her child? Or 3, Annabelle must apply for a parental order within 6 months of child X's birth? Naim Asapon, you're asking if you'll be invited to Lawyer Charles's party. Why not? You will be there. Am I going to be invited? Yes, definitely. You will be invited. Now, I'll keep your answers coming through. Let's see what you have. Derek Yeboah comes up first, and it says number 3. Annabelle must apply for a parental order within 6 months of child X's birth. Okay, thank you for that. Who else is coming up with anything? Because I'm going to go to Lawyer Charles Asma to quickly give us the answer. For this one, even me, I can get it correct. So let's see what you have. Tilly Duma says, number 3, Annabelle must apply for a parental order within 6 months of child X's birth. Okay, thank you, Tilly. Who else? I've got just about a minute more to get through to your answers and get over to Lawyer Charles Asma to help us unravel this. Who else is coming? Okay, Lawyer Charles Asma, time and tide waits for no man. Let's see what the answer is.
Okay, if we go through the nugget itself, the answer is hidden somewhere. So if you, Brakuku, read paragraph 2.
Under English law, the commissioning parents will need a transfer of parental responsibility to them from the surrogate mother and husband, if she's married, before the child is recognized as their child through a parental order within 6 months.
Within 6 months?
Yeah.
Right. So we go to the question. What does the English law say you should do, or Annabelle should do? So it's the question, what does the English law require before Annabelle is granted or recognized as the mother of the child?
Well, from the nugget, it said that a parental order should be sought from the surrogate parent, either the mother or if the mother is married, the husband together with them, within 6 months. And
Yes.
That's in paragraph 2 that you made me read.
So if we go to the options, child lives with Annabelle. Annabelle doesn't even have parental rights. Therefore, that child cannot live
with that. Okay.
Annabelle must apply for a British passport for the child. Annabelle is not even the parent, to the effect that we determine the nationality of the child to be that of Annabelle and get a passport for the child. Annabelle must apply to be a parent. Yes, Annabelle needs a parental order, and that must be done within 6 months. Then Annabelle can do whatever she wants to do again.
Okay. So the answer, as lawyer has explained, is 3. Annabelle must apply for a parental order within 6 months of the child's birth. Abnativo, you said 2. I've seen your answer. You said 2, which from the explanation and from what we have learned is not correct. I have Sandra Fraser saying number 3. Okay, that's fine. That's correct. So those who said number 3, you are correct. And with that, I would want to once again say belated happy birthday to Madam Cynthia Brown of BWF Solicitors Practice Manager. And we say, we love you. Congratulations. You won the Employee of the Month of August 2022. And later on in this month, you have celebrated your birthday. That's a double whammy. Thank you very much for being who you are. We love you to bits, and belated happy birthday. And of course, a fresh one from us on TV. Then again, we want to congratulate our brother, our friend, and our resource person, Lawyer Charles Asma, for completing and qualifying as a solid star after 3 years of training. Together, we say congratulations. He calls me Brago, so I'll call him Brachas. Congratulations, Brachas, for achieving that feat. It is no mean feat. You have done so very well. And having said that, I'll give him the opportunity to round up and we draw the curtains down for today's program. Lawyer Charles.
So hello, viewers and listeners. Today we have looked at how to have access to your children if there is misunderstanding between you and the child's mother, to the effect that you do not have access or you can't see the children. What you have to do is first speak to family, friends that mother respects. Speak to church if the mother goes to church, and respect the church leaders. So you can take that and discuss that, and if possible, solution will come from there. If that doesn't work, you can see a lawyer. Lawyer will then write to the mother of the child or the person with that guardianship to say that you should be given opportunity to see your children, and there you propose an arrangement and they agree to the arrangement. If that does not work, you have to go to court. Although the court, once you go to court, it becomes a formal process. So you apply, you pay the court fee. The court will ask you whether you've exhausted the informal process, and you tell the court yes. If it's not, the court will arrange for the informal process to take place, what we call the MIAM. So the MIAM process will take place. That is a mediation, information, and assessment meeting. That meeting will take place to help resolve the matter out of court. If that still doesn't work, then court will take over and make an order for you to have access to your children in terms of time they can spend with you or time they can live with you. And that arrangement will be proposed to you. It will go through a trial stage, and once the court is satisfied, it is finally confirmed. All this is done in the interest of the child, and therefore everything that is there is not for you, the father or the mother, seeking the right, but it is what is in the child's best interest. What it means is that you have to show that you have accommodation. You have to show that there's a place for the child, so to speak, so that the child's well-being is not affected. You have to show that you have time to look after the child. So you are not just seeking to have the child because you are the parent. You are seeking to have the child because you can exercise responsibility towards the welfare, well-being of the child. So the court will look at all that, and if the court is satisfied, the court will grant you. Once the order is granted, you have that right, and you are able to have access. If the other parent is not still willing or giving you opportunity, you go to court for the court to intervene. And it may be the case that they will tell the other parent off in a way because they have not complied with the order of the court to allow you to access the child. You should also make sure that you follow the order. If the order says at this time the child must leave and go back to where the child lives, you have to ensure that you do. If the order says that the child must be taken to a place because you cannot go near that mother or the parent of the child, the other parent, you have to follow that. So you just have to stick to that. And if you don't, or you miss without reason, the court will see you as not someone who can be trusted with the care of that child. So this is what we have learned today. We believe that it's been useful. If you still need more information on making an application, family application for child arrangement, for specific issue, for prohibited steps order, or for consent order, please do not hesitate to speak to us. Our doors are open to help you achieve whatever you want to achieve as far as your children's welfare is concerned. Thank you and good evening.
And with that, I draw the curtain star. I want to say thank you very much to every one of you. In fact, two more messages. One from Margaret Edumensa. Congratulations, Lawyer Asma. And the most important of all, I have one from Lawyer Bernard. Congratulations, Charles. We are proud of you. I couldn't have ended on a better note than this. My name is Ulrich Frimpong, and I have enjoyed your company, and I want to invite you to come and join us again same time next week on the program The Community and the Law. On behalf of Professor Ade, my studio manager and producer, Sheila and Padmo, and of course all the members of staff of BWF Solicitors here in the UK and back home in Ghana, want to say salute. We'll see you again next week. Good evening.